Kidding me? Hello?
Yes.
Okay, so I'm in. Okay. Why isn't my video working? Thought I had done that. There it is, it's back.
Hello?
Yes.
Is this the right link for the appeals?
Yes.
Have you started yet?
No.
Okay.
You're
So I
okay.
just need to hold on.
Just hold on, mute until we call your case.
Okay.
Good morning.
Morning.
Good morning.
Okay, if so, you can move it to the preamble since we're running so far behind. Mr. Chairman, you can go ahead.
Okay, in compliance with notification requirements of Ohio's open meeting law in section 101.021 of the codified ordinances of Cleveland, Ohio, 1976, notice of this meeting has been publicly posted. All boards and commissions under the purview of the city planning department conducts its meetings according to Robert's Rules of Order. Actions during the meeting will be taken by voice vote. Abstentions from any vote due to a conflict of interest should be stated for the record prior to the taking of any vote. In order to ensure that everyone participating in the meeting has the opportunity to be heard, we ask that you use the raise hand feature before asking a question or making a comment. The raise hand feature can be found in the participants panel on the desktop and mobile version and activated by clicking the hand icon. Please wait for the chair or facilitator to recognize you and be sure to select unmute and announce yourself before you speak. When finished speaking, please lower your hand by clicking on the raise hand icon again and mute your microphone. We will also be utilizing the chat feature to communicate with participants. The chat feature can be activated by clicking the chat button located on the bottom of the WebEx screen. Call-in users can unmute by using *6. All meeting activity is being recorded by way of the WebEx platform. These proceedings are also being live streamed by way of YouTube. All requests to speak on a particular matter by way of our website and email have been considered. We have also received emails from those who have provided written comment on a particular matter. Mr. Jacobson.
This TV real quick. Mr. Chairman, this is Dean Jacobson from the Law Department.
couple small preliminary matters.
Wait a minute,
Can we
Dan.
verify if the,
Wait a minute, Dan. Okay. There you go. Can you still hear us, Mr. Chairman?
Yes,
Okay.
Mr. Chairman, again, this is Dan Jacobson from the Law Department. I just wanted to clarify some preliminary issues. Can we verify that the live stream is on and functioning?
Yes, we are.
Excellent. And as the Law Department has done since these meetings have gone public and or virtual, or hybrid, law states its objection to the use of the chat function. Thank you.
okay, thank you, Mr. Jacobson. Ms. Davis?
Mr. Maschke,
Here.
Mr. Bradley, Mr. Bradley, you're muted. Mr. Dink,
Here.
Mr. Gallagher.
Here.
We have a quorum.
Okay, we'll call the first docket A 372-23, 3218 East 135th Street.
Application and fees are in order. Notice of violation is no permit. Please mute your mic until it's time for you to speak. Thank you. Calling user number 2, number 6. All calling users, please mute your mic.
I just muted everybody.
Thank you. Notice of violation is no permit in interior and exterior maintenance issued on October 5th of 2023. Appeal was received November 6, 2023. Requesting for time to abate the violations. Present for the hearing, Tom Vanover, Department of Building and Housing, Dan Jacobson Law. Will the appellant or his or her attorney or a representative please state your name and your capacity with this property? Is there anyone here from Boss Ross Realty LLC?
Yes, ma'am.
Also, Boss Ross Realty is represented by Attorney James Alexander, and I'm here. We have two representatives from the company, Mr. Robert Ross, who just spoke, and Ms. Edith Ross. And we're prepared to proceed.
Okay, all those giving testimony solemnly swear to tell the truth, the whole truth, so help you God?
Yes.
Yes. Yes.
Okay, who's ever going to be speaking, go ahead and let us know what the plans are.
All right. Yes, so good morning, distinguished members of the board and Cleveland public officials. Thank you very much for the opportunity to present this appeal on behalf of Boss Ross Realty. My name is James Alexander. I'm an attorney. Glad to be able to present this appeal to this board. Usually I'm involved in these matters when they've been charged as criminal matters in the municipal court. This forum permits us to present arguments and points of note that might impact the proceedings without having to be in the criminal court. First of all, let me state that the basis for this appeal is really two parts. The first part is that, as was stated in the introduction, my clients do seek additional time to make the repairs necessary with regard to the matters that they have control of and are properly charged for. The second part is that We contest most of the violations on the basis that my client is not the responsible party for those particular citations. A little bit of background. I'm sure some of these things are available to the board from the public record. But this is a property, dual use property as a storefront operation with 2 dwelling units upstairs. The primary use of the property is for the storefront, which operates as a convenience store, grocery store, beverage store type of business. And that business was established at that location long before my clients acquired the property. It was up and operating when they purchased it. During the time that they've owned it, the ownership of that location has changed. And in 2021, the owners entered into a long-term lease with those new owners for the continued operation of the property. And pursuant to the provisions of the lease, the store owner has exclusive control and possession of the storefront operation. Most of the citations that are issued from the September 6, 2023 violation list relate to that storefront operation. What I'd like to, the board also to notice, even though these violations are noted as October, let's see what we say, October 5th, we attached a copy of the envelope to our notice of appeal, which we invite you to look at. It shows that those violation notices were not mailed until October 19th. So the property owners didn't actually receive notification of these violations until sometime after that date. After receiving these notifications, my clients, being the responsible people that they are, immediately reached out to the inspector because they had no advanced knowledge of this inspection, either before, during, or after it occurred. And based upon those discussions, they also had contact with the store owner who was supposed to be taking care of many of the violations that are noted there. So that's by way of background. The other part I want you to know is that as a result of these violations and the fact that the store owner hadn't been paying rent for a period of time, the property owners have initiated an eviction action that's pending in the Cleveland Municipal Court, even as of this date. Hopefully you have in the record of your case, both a copy of the lease agreement that Boss Ross Realty has with the store operator, which is known as WICK, W-I-K-K Inc., and also a copy of the docket of the Cleveland Municipal Court case. So that's the factual background. So as to part one, with reference to the violations that my client knows is responsible for, they've already begun making some repairs. We could produce evidence of that to the inspector as required. We do request some time for 2 reasons. One is until we can get actual possession of that property, a lot of these repairs they can't even address. They don't have keys to the property. Under the terms of the lease, they don't have access to the property. And until the Cleveland Municipal Court acts to terminate the lease agreement that they have with present occupants and lessee, they really have no authority to be there. What I didn't say is the lease does not terminate according to its terms until September of 2026. If we are successful in the eviction action, of course, that would shorten that. But as we sit here today, I don't know what the outcome of that is going to be. The tenants have a lawyer who's talked in terms of some kind of compromise. They may turn the keys over, or they may file to contest the occupancy right to continue in the premises. So in short, we don't have control over that part. Now, as for this, and then the second part, of course, is the weather conditions. You know, it's starting to get better now, but we would look for, hopefully, a date, you know, after April 1st or somewhere like that, to begin making a lot of the external repairs that are called for here. Now, as to the matters that we want to contest, several things I'd like to point out. One is that it should, and I run into this a lot in the criminal court, housing court. Somehow or another, the inspectors always think all they have to do is to cite the owner, the title owner of the property. And I don't think that's what the ordinances contemplate. They actually contemplate service on the person that's in charge of the premises. I know it's always easier to contact the owner because that's a matter of public record. You can look it up, find out who the owner is and just serve them. But that's not always the best way to do this if your objective is to correct the conditions that exist. You know, who's responsible for that? What's the best approach to getting that done? As a matter of practice, if you intend to cite the owner, you should at least let the owner know, hey, I'm going to be inspecting your premises on such and such a date. Can you meet me there? Or some discussion about what you found when you did inspect, rather than issue this long list of violations. I think the ordinances do contemplate. Well, first of all, let me assure you, we're not contesting the right of the city inspectors to go into a property. That's their public duty, not on behalf of the public, on behalf of the city. We fully understand that. But there are also some due process rights here. Even when you have responsible owners like the Rosses are in Boss Ross Realty, they need to know what's going on with their property from the official's point of view. So when I look at the ordinance, let me see, I think it is 3101.05J. It doesn't just define an owner as the title owner of the property. It also defines owner as a lessee in control of the premises. And that's what we have here. We have a lessee in charge of the premises. So all of those violations that arise out of the September 5th, 2023 inspection that apply to the storefront operation, those should be just categorically dismissed or recited to the to the owner of the store operation. Now we
Mr.
do-
Chairman, if I may,
Yes,
can you restate that ordinance number, please?
I can tell you what I gave you was 3101.05 J, subsection J.
Thank you.
And it reads that that particular section reads, owner means the owner or owners of the premises, a vendee in possession, a mortgagee or receiver in possession, a lessee or joint lessees of the whole thereof, or an agent or any other person, firm, or corporation directly in control of the premises or having a legal or equitable interest in the property. The fact that my client got these citations in some ways is helpful because it identified issues that they were not previously aware of. Secondly, it gave them some heads up as to some responsibilities that they may have, they perhaps did not know they had. So for example, there are some citations here about not having permits for things that have already been done. Well, as I said, this store operation has been there for years. Those jobs were done by somebody totally beyond my client's control or knowledge. You know, I don't know how we're gonna fix that.
okay, Mr. Alexander.
Yes.
And I know you have been through some of this before, and I think because you're contesting certain parts of the violation, that maybe we can kind of cut a little bit to the chase here on those items, and I can go to maybe Mr. Jacobson, because you are contesting that who has the right to be charged in this. And I think maybe we can get an opinion from either him or from Mr. Vanover on how this goes down, and then you can respond.
All right, thank you.
Okay.
Thank you. Thank you, Mr. Chairman. Dan Jacobson from Law. Attorney Alexander, you're here on behalf of your client. What is the name of your client specifically?
Boss Ross Realty LLC.
Okay,
And like I said, on the first list, the very first list, they did cite both the store owner and Boss Ross. But for the major ones, Boss Ross is the only party charged.
Mr. Chairman.
Property records indicate that Boss Ross Realty is the current owner of the property, and they took title in 2021 from Robert Ross. So the current titled owner of the premises is Boss Ross Realty LLC.
Uncontested.
And Boss Ross Realty did get notice somehow of the violations
That's correct.
and referred that information to you. I also, as a preliminary matter, you stated that the eviction case was part of the record through the chairman Davis. Do you have any information regarding the eviction case? And if not, could you just, for the record, read in that case number of
Yes.
the eviction case?
Okay. Yeah, I was
Did you
gonna
want me
say,
to
That's all.
respond first?
Yes, I'm sorry.
1 second, please. To the chairman, to Mr. Jacobson, we did receive an emails from the appellant's attorney. He did submit to the board yesterday via email about, or this morning rather, at 8:22, Exhibit 1, the lease naming the leasee and also exhibit 2, the Cleveland Municipal Court case number 2023 C as in Charlie, V as in Victor, G as in George, dash 012934. We will make copies to submit to the Department of Building and Housing for their files.
Mr. Chairman, thank you, Ms. Davis. We will confirm that there is an active eviction case. Thank you.
Mr. Chairman,
Yes, go ahead, Mr. Vanover.
so while the code referenced 3101.05 under definitions does state the definition of owner has been explained or read into the record. It does not preclude the titled owner of the building from their responsibility. In fact, section 3101.09, and I'll repeat that for Mr. Alexander. 3101.09 of that same building code, City of Cleveland Municipal Building Code. Under responsibility of owner, subpart A, the owner of premises subject to the provisions of the building code shall be responsible for compliance with the standards set forth herein. He or she shall remain responsible, therefore, regardless of the fact certain responsibilities may also be placed on operators or agents. The owner shall remain responsible for the elimination of any violation found on his or her premises. And then there is an exception for permitted work that is hired out to be done. But subsection A requires that even if you write a lease subrogating your responsibilities to somebody else, that the titled owner of the property remains responsible.
Mr. Bradley, your mic is hot.
So the city's position, Mr. Chairman, to Mr. Jacobson's report, this property was transferred in 2021, and it is the responsibility of the property owners to understand and know the condition of their property. The fact that they entered into a lease for financial gain that prohibited them from their rights and responsibilities under the City of Cleveland codified ordinances is that is not a decision that the city or the public has made. We contend that they, regardless of what their civil contract states, that it does not overrule the law, and the law states that the owner of the property shall remain responsible even if they place those responsibilities on others. So, and the reality is the violations that exist, it should not be left to the city to expel resources to tell a property owner to take care of their property and correct violations. So we object, and we ask that you uphold the notice as properly issued, that it was issued to the owner, and that the owner does have a responsibility to correct the violations before we get there, and most certainly after the violation notice is issued. And that subrogating those responsibilities to a leasee does not remove the owner's responsibility to correct the violations.
Mr. Alexander, do you care to respond?
Yes. It appears to me that there's a conflict in the ordinances of the city of Cleveland on that point. And because there is a conflict under constitutional principles, the interpretation should be in favor of the property owner. And so I asked for a ruling on the issue. And so we can have a proper record to put it before a court if it comes to that. But that was not my only objection. I have others.
Understood, and I'm sorry to interrupt, Mr. Alexander, but yeah, I think I would like to have this issue addressed. And I think that we need a ruling on this before we move forward to the other objections.
I think you're right.
Mr. Chairman, we would also, the city would also state that under 3101.05 definitions of owner, it includes the fact that it includes mortgagees, receivers in possessions, leasees or joint leasees, or other agents in control, does not, it includes them in the definition of owner without precluding the titled owner. The fact that it includes multiple persons in the definition, and nowhere in that definition does it preclude one from also being jointly responsible. The ordinance as written makes all parties jointly responsible, including the titled owner of the property who is leasing it for profit.
Okay, so as a chairman of the board, and I'm going to go to the board also, that I believe that the notice was properly issued. And so, therefore, we can move off of this, but I'm going to get the other board and I'm going to ask them their opinion. Mr. Maskey.
I agree with you, and if that's a motion, so moved.
Okay, and Mr. Dank?
I think we should have a motion to direct the appellant to submit for a permit within a specified time, something like 30 days, and then proceed with the abatement of the violations, under the jurisdiction of the Ohio Building Code.
Okay, and Mr. Bradley? Mr. Bradley, are you muted?
He is.
Am I muted?
Yeah,
Something's wrong. You hear me now?
I can hear you. So,
You can?
yes.
Okay, I agree with you.
Okay. Okay, so the notice was properly issued and, we have a motion that was put out there by Mr. Dink, I believe. You want to restate that motion?
I'd like to make a motion that the appellant be directed to submit for permit within 30 days and then proceed with the abatement of the violations under the jurisdiction of the Ohio Building Code, maybe subject to the resolution of the eviction proceeding in municipal court.
Okay,
Mr. Chairman, discussion?
okay, go ahead.
Well, I think that the facts, and I know there's a motion on the floor that you have to deal with, but I don't believe the facts of the balance have been presented. There's 4 violation notices on this property, including an illegal use of interior maintenance, exterior maintenance, and no permit. So I don't, and we would object that. We would object to a motion that requires us to wait for some imaginary eviction date, right? Understanding that it's in process, but not knowing when that's going to happen or if that's going to happen. I will restate that the property looked like this when they bought it or when they transferred it. And this is a business venture that,
The motion was seconded.
but you have a motion on the floor.
Mr. Chairman, if someone would either second the motion before going or otherwise, I understand Mr. Vanover's position, but just so we stick with the rules, discussion is usually after that point, respectfully to everyone. So And I think he's raised a few issues which are important for the board and the appellant as well. But
Is this issue?
I second it.
Wait a minute, don't okay. Non-seconding it just kills the motion, okay?
Yeah.
Seconding it makes the motion alive, so.
Okay, then I'll withdraw my second if you want to
Okay,
rework.
all right,
Right.
second is gone, so we're gonna allow this to go until we hear the rest of this case.
Thank you.
And I believe that with that motion, and with what Mr. Vanover's saying too, as far as the eviction notice and all that, I think probably should be left out and let that go wherever that goes in a time frame that it's gonna go. But I think we need to deal with the property itself. So we're gonna have to go ahead and hear, I guess, the rest of this, parts of this that would pertain to the no permit and to the other parts. And so we can take them each out of here. We dealt with the one, and I think the board does believe that the notice was properly issued. Okay, so that's clear. So let's move on from there. So Mr. Alexander, and the other issues, because that's resolved, you can take that with you.
All right, let me try to be clear on, let me, before I continue, let me put it in the form of a question. With regard to the notice of violation, interior, exterior, can you state that in terms of what my client received was two separate violation notices, four separate violation notices, and they were given numbers. The first one was V23025-269. The second one was V23025-270. The third was V230-27056. And the fourth was V230-27057. And with respect to each of these violation notices, some were several pages long and consist of numerous citations. So for my purposes, relative to the notice of violation, interior, exterior maintenance, and no permit, I think what I'm understanding is the no permit is one issue. Interior violations is a second issue. Exterior maintenance is a third issue. And that those citations apply across all four of these violations. Am I correct?
Mr. Vanover.
What was the final part of your question? That what what applies to all four?
The way this is listed on your docket, your agenda, is it says notice of violation / interior, exterior maintenance and no permit dated October 5th, 2023. And that's not how my client got the citations. How they got the citations like what I got here. And I just enumerated them for you. I don't want to do it again. There's four separate sets of violation notices. I'm not sure what organizational criteria directed the inspector to categorize them in the way they did. But the way we have them is not the way they are identified on the docket. And as I look at these, chimney pricks, ceilings, walls, windows, security bars, I think we dispute that too. Porch system deteriorated, water supply, waistline. To me, that's like a synopsis of all four of these, as opposed to being directed to one or more of the violations according to the violation number. I'm not trying to confuse it, I'm trying to fix it.
So,
Am I-
Mr. Chairman, if I can opine for just a moment, it appears that there, 2 of the 4 notices are identified in the appeal statement using the October 5th date. I believe from what the appellate is, and just, I would like some clarity, Mr. Chairman, is it the appellate's understanding that an appeal was filed for all 4?
Yes, it is.
Okay, so Mr. Chairman, the city acknowledges that all 4 violation notices as listed by Mr. Alexander have been appealed, and that this hearing covers all 4. The synopsis of what is before the board, what we're looking at is for presentation in the hearing. It is not an exhaustive list. The violation notices stand on their own. This board's docket does not, or the information provided for the virtual hearing is not the point of truth for what the violation notices entail. Only to, as a matter, my understanding is it's only a matter of facilitating the hearing. We do not object to going through and handling them individually for the board to rule. And if I may, there's a stop work order and a no permit for electrical work that was done without, and panel boxes that were issued or that were installed without proper permit. We would ask that the board uphold that violation notice was properly issued and remand it back to the Department of Building and Housing, requiring the application and approval for a permit as quickly as immediately.
Okay, that's one part, which deals with the no permit. And so let's take that on, because I think that's something that you want to have done right away, because it could be a safety issue. So that doing it without a permit. So we're saying that a permit will uphold that, and the permit needs to be obtained, and then we remand it back to the city so that they can handle it and probably be re-inspected. I'm assuming, and then it needs to meet whatever the code says for what needs to be done for it. So I'm going to put that part of it in a form of a motion for the permit issue. So is there a motion?
So moved.
Okay. Motion by Mr. Maschke.
We need a date for the deadline for filing for permit?
Well, actually,
So
he's saying immediate. What's that?
it's a deny and remand, correct?
Right, it's a deny and we're putting the motion in order to deny and remand and to give it back to the Division of Building and Housing for any further action on it, because that needs to be taken care of right away with the no permit.
I'll second that motion.
That's totally unfair. How's my client gonna do this? He doesn't even have possession of his premises. You all don't get it. I mean, your fire department and your building inspectors can go in there and do what they want when they want. We got to get a court order to get in there.
Mr. Alexander, somebody went in there and attempted to do this without a permit. So obviously somebody has some authority to go do it. I'm not sure if that was Mr. Ross or who that was, but somebody did work without a permit.
Can I?
It was not my clients. That's how they got the property.
Can I say something, sir? This is Robert Ross. When we purchased the property, all of the electrical panels and everything was already done. The property, the way that the property is today, is the way that we purchased the property. We had no electrical work done in the property at all. So the existing electrical in the property is how it was when the building was purchased from the prior owner.
Okay, let me go back to Mr. Vanover.
Mr. Chairman, it is the responsibility of every purchaser of property to do their due diligence, to understand what violations exist, what work has been done, what legal processes were followed and which ones were not. While we understand the condition that that this owner doesn't have keys to the locks on his own building, prior to transferring property as a commercial and any real estate owner, it's their responsibility to make sure that work that's been done has been done legally and that the violations that exist. So while we understand the argument, I don't believe it's a matter of fairness. I believe it's a matter of prior due diligence to taking possession. And there are remedies outside of this board's authority to gain access to a property under tenant landlord law in the state of Ohio. And my experience has been that the court has a tendency to consider when city actions are filed on a property requiring the owner to correct things that those court orders, that all becomes evidentiary in the court order process.
Okay, so the motion stands in regards to the permit, the no permit. And Ms. Davis, you call the roll.
Mr. Maskey,
Yes.
Mr. Dink,
Yes.
Mr. Bradley,
Yes.
Mr. Gallagher.
Yes. Okay, so we have that portion taken care of. Now we have, what is it, three other ones in front of us here? We're talking about Mr. Vanover. So just to clarify, we're not going into detail on these, but the interior, exterior, that can all flow into the same thing, right?
Well, Mr. Chairman, we don't object to granting more time to make the corrections, the interior, exterior corrections, the exterior, that work can be done and begin immediately, without needing access to the interior of the property. So we would not object to a responsible and reasonable timeline to make the corrections for the interior, exterior violation notice. But we would ask that that be kept, we would ask for no more than 90 days with, of course, extensions if there's progress on that work.
Okay, what about permitting? Is there anything that needs to be permitted in that?
Based on the notice of violation, depending on how the owner attacks the corrections, it doesn't appear that there is a need for permits. But if, for instance, if they replace the water tank instead of repair it, then there will need to, then they will need to pull permits. So we don't object to time to get that work corrected.
Okay, so if permits are necessary, the permits should be obtained as they go into the work within 30 days, March 15th, 2024, for any of the work that needs it. And to correct all the violations, May 15th, 90 days, 2024, to abate all the violations. Motion?
So move.
Motion by Mr. Bradley,
Second.
second by Mr. Dank.
We have a date. Yeah, we have a date certain. Thank you.
Yes, the ending date, May 15th, 2024.
Mr. Maskey,
Yes.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Okay, notice will be sent out within 2 weeks. Thank you.
Mr. Chairman, so there's also, so the next notice of violation is a illegal use. This building per our records is 3 apartments and 1 storefront. They have been cited for transforming one of the apartments into a storage unit or storage use, which comes with its own hazards, specifically when there's residential dwellings. We would ask that you uphold that, deny any more time, and remand it back to the department, expecting that the illegal use be discontinued immediately.
Okay, so a motion is in order to deny more time on the illegal use and remand it back to the Division of Building and Housing for any further action. Motion?
So moved.
Second. Moved by Mr. Dank, second by Mr. Maschke.
Mr. Maschke,
Yes.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. A notice will be sent out within 2 weeks on that also.
Okay, I didn't get a chance to speak on that, but let me ask counsel if he would direct me in the record to the specific violation that he's referring to about the illegal, as you say, I think you used the word conversion. Although this is the way my clients acquired this property, which one of these?
Mr. Chairman, for the record, that is violation notice V as in Victor 230-25270.
2, 7.
I'll repeat that. It's a 230.
I see it.
Okay,
Yeah.
thank you.
Now, this is one is, okay. Well, continuing objection, I think you already indicated your intent to impose this. But this is beyond my client's ability to control at the present moment. We may eventually get control of this premises, but we don't have it right now. So all I can do is note my continuing objection.
Okay, thank you, Mr. Alexander.
And Mr. Chairman, finally, the notice of violation for the interior maintenance, which is the violation notice V as in Victor 230-25269. We would not object to more time to correct those violation notices, those violations, providing that it's a reasonable amount of time.
So that wasn't within the motion for the interior exterior.
No, this is a separate violation notice, Mr. Chairman.
We'll follow the same on it. If they're,
If I can be heard, if I can be heard on these, please.
yeah, on this one,
Yes. This is even more imperative. At least the inspector saw the need to include the actual property owner under the definition of ownership of this premises when she issued these citations, because they refer to not even building issues. These violations reference some mechanical refrigeration units that are inside of the store. Those units don't even belong to the building. They don't belong to the owner. How can you cite them with violating, not maintaining them in a proper condition. If anything should be dismissed, they should be dismissed, at least as far as they are relating to Boss Ross Realty. I don't see Week Inc. here representing themselves or having appealed this violation. So they might stand with regard to them, but how can you make the owner of refrigeration units that are not part of the building responsible for as building violations? So
Okay, we're
should
gonna
be
find
dismissed.
out, Mr. Alexander. I'm gonna ask Mr. Vanover to respond to that. Mr. Vanover?
So, Mr. Chairman, this notice of violation is specific to the refrigeration units and the cooling units for the coolers that are installed into the building. The code is clear on when it becomes part of the building and when it is not. However, I do not disagree with Mr. Alexander's position that these are appliances and devices that are owned by the owner of the business itself. And the owner of the business has a responsibility to maintain them. However, I revert to my initial statement that as a property owner, simply signing into a civil contract for profit does not release the owner's responsibility to cause these things to be corrected. I mean, the logic has been proven under the law, and as a property owner, you have to, if the civil contract does not provide remedy to cause the leasee to comply with the code, then the civil contract, in this case, the lease, is flawed. But that is beyond the realm of this board.
Yeah, Mr. Chairman, I'm sorry to interrupt, Mr. Vanover. Because we've not seen the lease, and again, this is not part of the realm of the board, as you rightly stated. We need to be a bit cautious when speaking to contracts and agreements the board has not viewed.
So,
Just putting that out there.
Mr. Chairman, I wholly agree, and I appreciate that. To clarify, I'm not speaking to the contract. I'm speaking to the appellate's characterization that the contract does not allow them to maintain these things or gain access to cause them to be maintained. I'm strictly not speaking of the contract, but I'm strictly speaking of the appellate's testimony characterizing their ability to do.
So what we're looking at is giving time so that they can correct it, or whatever means that they choose to use to force the people that are operating it, or however they do it, to go ahead and take care of this. But there needs to be some time in there to be able to correct this. And so what we're looking at is, again, that March 15th, 30 days, if they need to have permits in this, to go ahead and obtain them, and 90 days, May 15th, 2024, to abate the violations. Motion?
So move.
Second.
Okay, moved by Mr. Bradley, second by Mr. Denk.
Mr. Maschke,
Yes.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Mr. Vanover, does this complete all the items?
Mr. Chairman, this is the appellate's appeal, but from our records, those are the 4 violation notices that have been issued on this property. And from testimony, it is my understanding that these are the 4 violation notices that the appellate expected to appeal. But whether there's additional items or orders out there, I would leave that to the appellate to opine on.
that there's anything else that hasn't, we haven't addressed?
Well, there is one other matter that I would bring to the board's attention. With respect to V230270056, the inspector made numerous citations regarding the violations in the store unit, citing various provisions of City Codified Ordinance 369, various parts of 369. I'm asking that those be dismissed on a different ground, because, and I'm just a lawyer, I mean, the courts have to make these determinations ultimately, but I believe that's 369.13, 369.15, 369.16, and the others listed there, they all relate to violations of the housing code, which would not apply to the storefront location. Those are improper citations. And I also like to address the one at oh, I see, these are conveniently numbered. So number 10, 11/4/2023, we just disagree with this. So, I mean, somebody would have to tell us how security bars, now those are put there for the protection of everybody. Security bars on the first floor window openings constitute a hazard. Remove. So let the record show that we disagree with that. That should definitely be stricken. That's an improvement, not a violation.
So, Mr. Chairman,
Yes.
couple of things. This is, there's been a motion and there has been and it has been voted on. But these are valid points that I think that Mr. Alexander has the right to address. I don't know the process by which we go back to this once it's been voted on, but I agree that there's value to do so. And I do have questions regarding Mr. Alexander's defense. And I think I think it could be brief, but I don't know the mechanism by which you open this back up, but I think you should.
We reserved this even throughout the discussion. I always said we had other arguments. That's one of them. Well, actually, that's the last one.
Okay, so Mr. Alexander, I've asked the chairman on positions. Let's let him speak. I think you and I agree on this.
Okay, who's speaking now?
So, Mr. Chairman, ultimately, what we're asking is, I think that this violation notice for the exterior maintenance has been heard. It's been voted on. And now, before it's finalized, we ask that you open it back up for discussion and revote based on what I don't know how that gets done.
In the beginning. Okay, so
Mr. Chairman, is the ask from both parties to rescind the motion? Are both parties going to speak to the issues you've already that the board members have voted on? Is that the ask? We've been looking at this issue by issue. It would be good to give the board an idea of all the issues that are going to be presented, and then the board can move accordingly. So you can rescind this motion, but we just want to be clear about what is being asked. Are both parties wanting to present on the same issues, and is the board willing to rescind the motion? If yes,
Well-
you take a vote.
The problem that I have with it, Mr. Vanover has stated that like within this premises and all the different things that are in there that need to be taken care of, kind of falls underneath that section that you read. And if there are things in here or reasons, if there's bars on windows or something, there may be a legitimate reason to have them or not to have them. If it is a fire violation, I don't know. But there may be reasons why it was cited. I don't know that I want to reopen this up. If it's already included, then I think Mr. Alexander certainly has other options that he can take on this. That if he feels that 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 it should go a different way, he does have other options available. But I think in all of this, we've given time to go ahead and correct these situations. And if he still disagrees with some of them, then so be it. I think he can take it up with somewhere else. Vishnu, does that sound?
Yes, Mr. Chairman, it will be up to the board. What I'm understanding is you do not want to rescind the motion. You maintain it as it stands, and you've provided ample opportunity for both parties to speak to the issues and present evidence. That is what I'm hearing.
That's the way I feel about it, Mr. Dank.
That's acceptable to me.
Okay, Mr. Bradley.
Also me.
Okay, all right. So anyways, we're in agreement on that. We're going to leave it as it stands. You'll get the notice within 2 weeks, Mr. Alexander. That'll come out, and this will conclude this docket. Thank you.
The only thing else I want to say is my clients are not interested in spending a lot of money on legal fees, contesting legal points. What they are interested in is getting control of the property so that they can do the things that have to be done to comply with the law. They are that kind of responsible citizens. I'm disappointed. I don't think that even with the time you've given them, that's going to be enough. I should have said in the beginning that one of the one of the parties for the store owner is a lawyer and he knows the system, and we may not have possession of that property even as of our next court date, which is scheduled for February 20th. You got us starting in March. Fortunately, Cleveland Municipal Court has more jurisdiction on these kind of things than other municipal courts, so we don't have to worry about ending up in the Court of Common Pleas. But I'm saying now, for the record, Ian, I don't know that they, being as zealous and forthright as I know they are, that these kind of violations can be corrected by them if it ends up on them by the May date that you have set for them for final compliance. And unlike the characterization the council used as a contract for a profit, trust me, this is a contract for loss, extensive loss. And so in addition to the money they invested in a property that now they know came with some numerous violations that you all didn't make the previous owners own up to. They're gonna make them pay for them. So I just want to conclude on my client's behalf with that comment. Your record will be what it is. Thank you very much.
Thank you, Mr. Alexander. Okay, we're gonna move on to the next docket. Docket A 30723 dash 23, 4438 East 141st Street.
Good morning.
Application
Morning.
and fees are in order. Notice of violation is interior and exterior maintenance, issued on September 21st of 2023. Appeal was received October 8th of 2023, requesting for 6 months to abate the violations. Present for the hearing, Tom Vanover, Department of Building and Housing, Dan Jacobson Law. Will the appellant or his or her attorney or representative please state your name and or your relationship to this property?
I am Pippa Carter, and I am one of the owners of the property.
Okay, Ms. Carter, solemnly swear to tell the truth, the whole truth, so help you God?
I do.
Okay, go ahead and let us know what your plans are.
All right. Well, the residence was occupied by a tenant who, due to non-paying for year and a half, I finally did the eviction. She was represented by legal aid, and she did not move out when she was supposed to move out. So I've just been having a really hard time because of her not paying and also not moving to get in and to do the work. Yeah, the outside needs painting, and there's no question there. But she has finally moved out last month, and I'm going to go ahead and address the issues as soon as possible. I just need a little bit more time now that she is gone, because she was pretty hostile, and get this done. So I would like, another 6 months, like 3 months, actually.
Okay, Ms. Carter, I do have, I just realized I have one of our board members is gone. So we are now down to a 3-member board, which means that if our decision is not unanimous, which it usually is, then your appeal goes back to the city. If for that reason you prefer not to have your case heard, then let me know now, or for anyone else that's out there, before we call your case up, or when we do call your case up, let me know that you'd like to reschedule. Okay, so now we got that statement made. You wish to proceed?
Yes.
Okay, very good. So you were looking for like 3 months is what your ask was?
Yes.
Okay, let me go over to Mr. Vanover.
Mr. Chairman, we have no objection to 3 months with the expectation that the unit is currently vacant and that the exterior will be addressed first.
Okay. Yeah.
You got that.
Yeah, my understanding, it is vacant, although, she was working with legal aid. She never gave us keys because she was supposed to drop the keys off to legal aid. We never received anything from them, but we have driven by, and it is finally vacant.
Okay, very good. All right, so we're looking at May 15th, 90 days, 2024, to abate all the violations. And that should take care of it. Okay, motion?
So move.
Second.
All right, motion by Mr. Bradley, second by Mr. Dank, and it is to remain vacant until you complete the violations. Call the roll.
Mr. Bradley? Mr. Bradley?
Yes.
Mr. Dink?
Yes.
Mr. Gallagher?
Yes. Okay, you'll get a notice within 2 weeks. Thank you.
Thank you so much.
Okay, next docket is A 36223 11510 Rutland Avenue.
Application fees are in order. Notice of violation is interior and exterior maintenance, no permit. Issued on September 29th of 2023. Appeal was received October 25th, 2023, requesting for 9 months to abate the violations. Present for the hearing, Tom Vanover, Department of Building and Housing, Dan Jacobson Law. Will the owner or his or her attorney or representative please state your name and your capacity to the structure?
My name is Carmen Harwell. I am the owner.
Hey, Ms. Harwell, solemnly swear to tell the truth, the whole truth, so help you God?
Yes.
Okay, go ahead and let us know what your plans are.
Well, since the last time, the violations have been corrected. I'm currently waiting for a callback from Inspector Arnold. The tenant has vacated the property and reinspect whenever you need to. I'm not sure that I'm going to re-rent or rent out again this property, but at least they've been addressed.
Are you planning on staying in the property yourself?
No, not at this time.
Okay, so you may not re-rent, but okay.
Yeah.
What about the issue of the permit?
The permit, I believe, you're talking about for the corrections done?
Yes, I have a, I think there was a no permit violation.
Oh, I'd have to refer to the guy that I have met property about that. I thought that taken care of.
We can figure that out with Mr. Vanover. Let's see, time, how much time do you think you need?
At least 3 months.
Okay. All right, Mr. Vanover.
Okay, so Mr. Chairman, I do have, I've heard two things in the testimony. One, that the violations have been repaired, awaiting a reinspection, and the request for 3 months to make the corrections. So I'm asked for some clarification.
My fault. I misunderstood. No, I do not need 3 months for extra repairs.
Okay.
I mean, to get those done. My fault.
So Mr. Chairman, you are correct. There is a notice of violation for work that was done without a permit. It appears that there was a rebuild of the rear patio that requires a plan approval and permits. We would ask that you uphold and remand that back to the Department of Building and Housing. And with the expectation that the permits and the plans will be submitted immediately. And as for the violation notice for the maintenance issues, we don't object to 30 days so that the appellate can connect with with the inspector and get it signed off and closed. It has not been closed yet, but it sounds from testimony like we're just waiting for a final inspection on that. So we don't object to another 30 days to get that final inspection happening.
Okay, so you want the to remand it back to the Division of Building and Housing in regards to the permitting?
Correct.
Okay, and 30 days, which would be March 15th, 2024 to abate to abate the violations. Motion?
So move.
Moved by Mr. Bradley,
Second.
second by Mr. Dink.
Mr. Bradley?
Yes.
Mr. Dink?
Yes.
Mr. Gallagher?
Yes. Okay, notice will be sent out to you within 2 weeks. Thank you.
Thank you.
Okay, we're looking at the next docket is A 36423 2086 West 89th Street.
Application fees are in order. Notice of violation is interior and exterior maintenance and no permits. Issued on October 5th of 2023. Appeal was received October 23rd, 2023, requesting for 120 days to abate the violations. Present for the hearing, Tom Vanover, Department of Building and Housing. Dan Jacobson Law. With the appellant or his or her attorney or representative, please state your name for the record.
Sure. My name is David DeVorn. I am the attorney for the appellant. I have with me calling in on the call, manager of the appellant, Jay Mitri. In addition, the contractor that was retained by the appellant to perform the work, Dale Loshon.
Okay, all those that are going to be giving testimonies solemnly swear to tell the truth, the whole truth, so help you God?
I do.
Okay.
I do.
Very good. Okay, who's going to be speaking? Mr. Varner?
I will start.
Okay, let us know what your plans are.
Well, my understanding in waking a communication from Mr. Loshon and Mr. Mitri is that the vast majority of the work, almost all, 98% is what I've been told of the work has
Mr.
been.
Chairman, 1 second. We're getting real bad feedback from his mic in here. I don't know if you guys are hearing it online. Do you have multiple devices open? Or are you close to your mic? Because
I can move up, but that means
Okay.
you will have to see my face a little bit more than, I don't know how comfortable the board will be with that, but
I'm picking up what you're saying, so go ahead.
calling from where?
Call-in users, I just muted them.
Okay, thank you.
you're welcome. And so as I was saying, my understanding is that 98% of the work has been completed. The permits have been obtained. We're waiting for a final inspection from the city, and there's some drawings that need to be done. We requested, a relatively brief period now to get this, the final inspection to occur. And the issue that I have with 30 days is that sometimes it's difficult to coordinate with the final inspection. If 30 days is permitted, that if for some reason we're not able to get that inspection to no fault of my client, we can file something or get an additional extension of period of time for the inspection to occur.
Very good. Okay, Mr. Vanover.
Mr. Chairman, based on the record, there was a permit to raise the garage that has been satisfied and completed. However, the building permit, has not yet been issued. It was submitted on January 29th, just 2 weeks ago, for review and approval. It has not been issued yet. So any work that is taking place under this building permit is being done without a permit. And so I'm not sure how 98% of the work is done when the permit hasn't been issued yet. That being said, there is an illegal occupancy of the third floor that is being occupied without approval. And that is the purpose of the no permit, as well as the illegal occupancy violation notice. I ask Mr. Chairman through the chair to the appellate, what is the expectation for that illegal occupancy? Did the permits cover it and there's been provisions made for it to be inspected?
Go ahead, Mr. Varn.
Okay, I'm going to defer to my client with. I want to make sure that I understand the question correctly, because I'm looking at two permits that one being P 23031946 for plumbing that was dated 224 in the permitted work complete. I'm also looking at another permit that was dated, or that is permit number E24003471. That was for, not sure if it doesn't say final, it's not circled final on that one. So I'm unclear as to what permit, if Mr. Vanover has these documents, or has seen them. With respect to the third floor, I would like to pose that question to my client. If I'm understanding it correctly, there is the contention that there's an unlawful occupant or somebody's occupying that third floor and is not permitted to do so. Is that the
Yes, that's what he's saying. I'm not seeing that on this notice, but if
So,
it's a part of this permit.
Mr. Chairman, to clarify, violation notice, and again, violation notice number V as in Victor 230-26565 may or may not be involved in this appeal, but it was issued at the property at the same time as the others. And it is for the illegal occupancy of the third floor. This is also the work that is stated in the no permit violation, which is V230-23892.
Okay.
So my question is, building permit number B as in boy 24002628 was submitted to the Department of Building and Housing on January 29th, 2024. And that was 2 weeks ago. That has not been approved. And my question to the appellate, does that permit application expect to resolve the illegal occupancy of the third floor?
Okay. You may have to ask somebody, Mr.
Yeah.
Warren.
Mr. Mitra J, are you there?
Yes, excuse me. Yes, I'm here. And if I can, Mr. Dale Loshan is on another device, and he's the contractor, and I'm sure he can give a good explanation for all this.
Okay, go ahead. Is he unmuted?
Star 6 to unmute. If you are a calling user, hit star 6 to unmute yourself.
Am I okay now? Am I
Yes.
being heard?
Yes.
Yeah, now you are.
Okay. Good morning to the board. This is Dale Lochan, contractor, Western Reserve Renovations, for Jaleel J. Mitri for the property located at West 89th Street. Thank you for hearing the time of the board this morning. Mr. DeBoer, thank you for allowing me in also. To address some of the statements that have been made, first, I'd like for the record that the property was purchased by the LLC in the condition currently under violation. The third floor attic was all finished prior to purchase of the property, and the porch, second floor porch, was already enclosed prior to purchase. But we recognize that the ownership owns that. Whatever violations would have been acknowledged before, after, and or during, we acknowledge with ownership that we need to be compliant. That being stated, since the violations have been brought to the attention of the ownership, we have gone down, purchased current plumbing certificate for plumbing permits, electrical permits, which have been amended. And we also wanted to apply for the building permit. However, the key back on the building permit was obtaining drawings to submit for review. The drawings have been submitted for review. The second stage has been addressed for the continuance of the planning process. So I guess that the that first stage, that the drawings were adequate and they could read them, have now been paid with the second payment of 20 some odd dollars just the other day, which will now send that drawings to plan review. Other than that, we have opened up the property for the building inspector, for the plumbing inspector, for the electrical inspector. And we are, for those two trades, plumbing and electrical. Plumbing has been closed out. We're finally installed on the plumbing. The electrical rough-in has been approved. If those certificates have not been obliged to the court, I apologize. We scan those in at the 11th hour so that they can be made available immediately. With reference again to the drawings, they are still in workings. So I would take, not offense, but I would take some note that we have been working on the property in fruition and completion, pending the visual aspect of the notching that the inspector had noted on the building permit. Illegal notching would be some floor joists and whatnot, and in compliance to bring everything to close with the third floor illegal, what they say is illegal occupancy, and also the enclosed porch. Everything we reassure has been addressed and is open to current inspectors. I hope this answers your question. If there's anything for rebuttal or readdress, please feel free. Thank you.
Mr. Vanover.
You're muted, Tom.
Mr. Chairman, to Mr. Lochin, through the chair. So to be clear, the plans that you submitted include the third floor renovation of the porch and the attic for occupancy? Yes or no?
Absolutely, yes.
Okay.
Correct.
And Mr. Chairman, I will restate that the law requires that the plans are approved, the permit is issued, and then the work is done. But I will also state that to the testimony, so you're saying that there is an electrical permit that has been issued and inspected. There has also been a plumbing permit issued and inspected. However, our records do not show that the plumbing work has been signed off as final. That may just be a matter of updating the record by the inspector, but the last inspection record that we have for the plumbing was from the 12th. And it was a final inspection with status of work in progress, which indicates, I'm sorry, that's February 12th, which indicates that there was still more work to be done. That being said, Mr. Chairman, we don't object to 90 days to complete what is required and to abate the violations.
And that will take care of all of this.
That is
May I?
Mr. Lochin? Is that
Yes,
who
may
wants-
I?
Yes.
Yes, Dale, yes. I have a goldenrod in presence signed by Inspector Dockler. I also submitted, again, the green tags at the 11th hour yesterday, noting that the final rough-in was, or I'm sorry, yes, proper terminology. The rough-in final was achieved for the electrical. Now we're waiting, we have some panel work to do and final installation of fixtures for the final inspection. In regards to plumbing, the green tag was issued, final job closed. And once again, the building permit inspector Derek has been privy to come to the property and look at all the unclosed areas. We have not closed up any area that work needed to be performed as far as structural requirements. The third floor was already finished, complete, prior to this violation notice. The property was purchased that way. We did all the upgrades necessary to comply, electrical and plumbing with that. There were no demolition for removal of walls to make those access. Also, the second floor porch, to reiterate, that the resident was using as a sleeping facility is still no longer a sleeping facility. It is going in as a porch, enclosed porch. We also, I stated with the electrical inspector, no plugs to be in that location because we don't want it used as a living area. And it is an unconditioned space, which will also not meet the requirements. I hope this answers and gives clarity, again, to your question and good direction. Thank you.
Mr. Lochin, the city has no problem with 90 days to abate whatever violations and to have whatever inspected needs to be inspected, taken care of. Does that meet up with you by May 15th, 2024?
It sounds good to me. It all is contingent upon the plan review and moving forward. Again, the visual aspects have been looked at, but we cannot get confirmation from the inspector because as the court records show, there is no permit issued, so we cannot get completion or even satisfaction to say it looks good.
Okay.
We're working to spec.
Okay, I think that can get done then. Motion is in order for May 15th, 90 days, 2024 to abate the violations.
So move.
So moved.
Okay, moved by Mr. Denk, second by Mr. Bradley.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Okay, thank you. Notice will be sent out within 2 weeks.
Thank you.
Thank you to the court.
Thank you.
All right. Next docket, A 36523, 1111-4 Willowmere Avenue.
Application and fees are in order. Notice of violation is condemnation of the main structure issued on September 6th of 2023. Appeal was received October 26, 2023, requesting for 60 days to abate the violations. Present for the hearing, Tom Vanover, Department of Building and Housing, Dan Jacobson Law. Will the appellant or his or her attorney or representative please state your name and your capacity to the property?
Hi, my name is Matt Coach. I'm the owner of C&B Cleve LLC that owns the property.
Okay, solemnly swear to tell the truth, the whole truth, so help you God?
I do.
Okay, go ahead and let us know what your plans are, Mr. Coach.
The house is going to need more than 60 days. We're going to need a full renovation of the whole house. Siding work needs to be done, roofing work needs to be done. Interior, we have to do all new drywall, new flooring, every single thing pretty much needs to be done, all new mechanicals. So we're just asking to get the permits started. I have a contractor who's ready to pull permits as soon as you guys allow, but it's probably more of his timeline is 3 months. So 3 months plus however long permits take and delay. So that is the plan is to get the house basically to a rent standard passed off by inspectors and the city and up to code and up to standard. So we don't want to fight in any way. We just want enough time to basically get that fully accomplished.
How much time do you think you need?
6 months.
6 months. Okay, Mr. Vanover.
Mr. Chairman, to the appellate, when did you take possession of this property?
September 26th,
Of which year?
2023.
2023. So, Mr. Chairman, to the appellate, it was condemned when you purchased the property.
Yes, it was. I made the offer before, and then it got condemned during basically the offer process between when I made the offer and when we closed.
Mr. Chairman, we don't object to 2 weeks to make application for the required permits and 180 days to fully abate the violations under the provisions of the Residential Code of Ohio.
Okay. That's what we'll do. So 2 weeks of permit up, February 28, 2024, and August 15th, 180 days, 2024 to abate the violations. Motion?
So
Moved by Mr. Bradley,
second.
second by Mr. Dink.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Okay, notice will be sent out within 2 weeks. Thank you.
Thank you.
Next docket is A 366-20-23, 4486 West 28th Street.
Application and fees are in order. Notice of violation is interior and exterior maintenance, issued on October 6th of 2023. Appeal was received on October 26th of 2023, requesting 4 to 6 months to abate the violations. Present for the hearing, Tom Vanover, Department of Building and Housing. Dan Jacobson, Law. Will the appellant or his or her attorney or representative please state your name and your capacity to the property? Mr. Chairman, I do not see a Demetrius Francis in our participant panel, and they are not present today in room 514.
Okay, Mr. Vanover solemnly swear to tell the truth, the whole truth, so help you God.
I do.
Mr. Jacobson.
Through the chairman to Commissioner Vanover, were any permits pulled on this, or was there any communication done regarding this property?
To me, Mr. Chairman, I have not had any communication. And the records do not indicate that there were any permits. However, I don't know that there were permits required.
Through the chairman to Ms. Davis, did notice of today's hearing get returned to the board's file for any reason?
Through the chair to Mr. Jacobson, no.
And through the chair to Ms. Davis, have you received any form of communication, an email, voice message, or anything physically delivered to you on behalf of this appellant and or docket?
Through the chair to Mr. Jacobson, I'm just looking at the file and notice that this appellant did have an attorney in our case file. However, the notices did not go to his attorney. The meeting notices or today's meeting link did not go to their attorney. So with respect, I would ask that we reschedule this one for a later date to give them opportunity to speak.
Okay.
Mr. Chairman, discussion?
Yes, go ahead.
Prior to making a motion.
Go ahead.
Our records indicate that, the interior exterior notice of violation was inspected and closed December 21st, 2023. And there are no open violation notices on this property. And I would only, I can only assume that's why they're not here, is because the violations were corrected and the inspector indicates that it is closed.
Okay,
So we would not object to granting time. I'm unclear what the appeal statement requested, but we would not object to granting time until today.
okay,
Noting that the violation notice has been closed.
okay. So being that the violation notice is closed, we'll give to February 14th, 2024, to abate the violation. Motion? Motion by Mr. Bradley,
Second.
second by Mr. Dank.
Mr. Bradley,
Yeah.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Okay, notice will be sent out to him within 2 weeks. Next docket is A 368-23, 9306 Dennison Avenue.
Application and fees are in order. Notice of violation is hazardous conditions. Issued on October 10th of 2023. Appeal was received October 23rd of 2023, requesting for time to abate the violations. Present for the hearing, Tom Vanover, Department of Building and Housing, Dan Jacobson Law. Will the appellant or his or her attorney and/or representative please state your name for the record and your capacity to the property?
Good morning. May it please the board, Attorney Patrick DeChiro, and I represent the owners, Kevin Van Gilder and his wife, Jeanette.
Mr. Chiro, solemnly swear to tell the truth, the whole truth, so help you God.
I do.
Okay, go ahead and let us know what the plans are.
Thank you, Mr. Chairman, distinguished members. The house on September 23rd, 2023 was run into by a truck, Ram 1500. The Cleveland Police did a good job, investigated the matter. The driver was drunk. City of Cleveland Prosecutor's Office did a good job prosecuting the matter. Unfortunately, there's no insurance from the driver. So my clients have been pursuing State Farm. State Farm finally has gotten ServPro out there to permanently board out the place, but the engineering report didn't come down till November, and the damages right now are estimated at $73,000, but we're not sure they include everything because some of the doors now are off center. The house has just been all knocked off center. So we need a little time, maybe 180 days to resolve this with the insurance company. We got to get a second engineer out there, and hopefully it's going to be done in the month of this month, and have it reassessed and the appraisal redone. There is a mortgage on the property, and my clients have fully cooperated in the prosecution of the gentleman who was driving drunk and hit their house. So we would just pray for some extra time. And like I said, some of the cleanup in the basement is done, and ServPro, who was recommended by State Farm, the insurance company, has come out and permanently boarded up the house. But now we have issues. So that's the best way I could say it right now.
Okay.
Thank you.
Very good. Mr. Vanover.
Mr. Chairman, bear with me for just a moment. So, Mr. Chairman, to the appellate, this is an owner-occupied structure, correct?
Yes.
Our records show that in August of 2023, there was a certificate of disclosure filed for the property and indicating an expectation to sell the property?
Yes, that's since that deal's going on. That was before the house got hit. Yes, we had a potential buyer and this is where we're at.
Okay,
We're
so,
gonna move-
so
yeah,
Mr.
yeah.
Chairman, to the appellate, we do not object to the 180-day request to make these corrections. With the understanding that the time extension is for the property owners to correct the violations,
Yes,
not to sell the property to somebody
Yes.
else.
yes.
Okay, that's understood. So that being the case, we'll do August 15th, 180 days, 2024 to abate the violations. Motion?
So move.
Moved by
Second.
Mr. Bradley, second by Mr. Dink.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Notice will be sent out within 2 weeks. Thank you, sir.
Thank you, thank you, thank you, Mr. Chairman. Thank you.
All right, next docket, A 369-23, 3824 Burwald Avenue.
Application and fees are in order. Notice of violation is exterior maintenance and fire damage. Issued on September 8th of 2023. Appeal was received October 23rd of 2023, requesting for 2 months to abate the violations. Present for today's hearing, Tom Vanover, Department of Building and Housing, Dan Jacobson Law. Will the appellant or his or her attorney or representative please state your name and your capacity to the property? To the chairman, I do not see Tara Kane
Okay,
or Brandon Kane in the participants panel.
okay. Mr. Vanover, solemnly swear to tell the truth, the whole truth, so help you God.
I do.
Mr. Jacobson.
Through the chairman to Ms. Davis, did notice of today's hearing get returned to the board's file for any reason?
To the chair to Mr. Jacobson, no.
And through the chairman to Ms. Davis, have you received any form of communication, email, or voice message, or anything physically delivered to you on behalf of this appellant and or docket?
To the chair to Mr. Jacobson, no.
To the chairman, the due process requirement of notice having been given to this appellant, the board can proceed with its hearing and ruling today. Thank you.
Thank you. Okay, Mr. Vanover.
Mr. Chairman, we ask that you deny any more time and remand this to the Department of Building and Housing. This was a fire damaged property that, as you can see from the photos, there's a considerable amount of exterior debris and stuff in the property, but it's also, the yard is, the yard has been in this condition. And the inspector reports that no progress has been made for a cleanup of any kind based on the fire. And there's indications that this property is just being used for storage of stuff and not actually inhabited. So we would ask that you deny any more time, remand it back to the department.
Okay, based upon the video evidence and the comments made by the city, motion is in order to deny more time, remand the property Division of Building and Housing for any further action.
So move.
Moved by Mr. Bradley, second by Mr. Dink.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Notice will be sent out within 2 weeks. Next docket A 371-23 16207 Park Grove Avenue.
Application and fees are in order. Notice of violation is exterior maintenance. issued on October 6th of 2023. Appeal was received November 6th, 2023. Present for the hearing, Tom Vanover, Department of Building and Housing, Dan Jacobson Law. Will the appellant or his or her attorney or representative please state your name for the record? Mr. Chairman, I do not see who? He's the attorney for that? Oh. This is, I do not see Joseph Otonichar on the display, on the participant panel or present today.
Okay, Mr. Vanover solemnly swear to tell the truth, the whole truth, so help you God.
I do.
Mr. Jacobson.
Through the chairman to Ms. Davis, did notice of today's hearing get returned to the board's file for any reason?
No.
And through the chairman to Ms. Davis, have you received any form of communication, an email, a voice message, or anything physically delivered to you on behalf of his appellant and or docket?
To the chair, to Mr. Jacobs, no.
To the chairman, the due process requirement of notice having been given to this appellant, the board can proceed with its hearing and ruling today. Thank you.
Okay, Mr. Vanover.
Mr. Chairman, this is an exterior maintenance violation on what appears to be an occupied rental property. And we would ask that you deny more time and remand it back to the department.
Okay, motion is in order to deny more time, remand the property to the Division of Building and Housing for any further action. Motion.
Move.
Okay, moved by Mr. Bradley, second by Mr. Dink.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Next docket, A 37423, 10201 Gibson Avenue, apartment number 2.
Application and fees are in order. Notice of violation is no permit, interior and exterior maintenance. Issued on October 5th of 2023. Appeal was received November 2nd of 2023. Present for today's hearing, Tom Vanover, Department of Building and Housing, Dan Jacobson Law. Would the appellant or his or her attorney or representative state your name for the record and your capacity to the property?
Attorney Eric Allen, a representative for Fireside Estates LLC, the title owner.
Okay, Mr. Lane, solemnly swear to tell the truth, the whole truth, so help you God.
Of course.
Okay, very good. Go ahead and let us know what the plans are.
My understanding is they've got some contractors that are going to be doing some work. I don't know exact date they're looking at starting. I don't know if anybody knows when a contractor is going to start, but they're looking for 60 to 90 days at least to get this taken care of.
Okay, Mr. Vanover.
So, Mr. Chairman, there's multiple violation notices on this property, including a no permit for finished attic and electrical and plumbing work regarding the occupancy and the build out of that attic. Mr. Chairman, to the appellate, is this property currently occupied?
I'm not aware of that. I don't know that answer. I'm sorry.
So, Mr. Chairman, this is a rental property that has a third floor attic conversion. It is an investment property. It is corporately owned. We don't object to more time with the understanding that the no permit violation notice, the interior and exterior maintenance violation notice, and the illegal use violation notice must be satisfied. We don't object to the 60 days that was requested.
Okay, so with all that in mind, we'll move for 60, April 15th, 60 days, 2024 to abate the violations. Motion? Motion by Mr. Bradley,
Second.
second by Mr. Denk.
Mr. Bradley,
Yeah.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Okay, notice will be sent out within 2 weeks. Thank you.
Mr. Chairman, discussion?
Yes, go ahead. Mr.
Just for
Vanover.
clarification to council for the owner, this property by definition is a corporately owned property, is a rental property, and does not currently have a current rental registration with the city. So be reminded to work with your client to make sure that that is accomplished.
Absolutely.
Okay, that takes care of it. Thank you.
Thank you.
Okay, next docket is A 375-23, 14742 Judson Drive.
I'm sitting here. Application and fees are in order. Notice of violation is interior and exterior maintenance, issued October 19th of 2023. Appeal statement was received November 8th of 2023. Present for the hearing, Tom Vanover, Department of Building and Housing. Dan Jacobson, Law. Will the appellate or his or her attorney or representative please state your name for the record? Go ahead.
Billy Bridges. Aye.
Did you hear that, Mr. Chairman?
Mr. Bridges?
Yes.
Okay, I solemnly swear to tell the truth, the whole truth, so help you God?
Yes.
Okay, go ahead and let us know what your plans are.
Okay, number one, she had bad credit. I bought the property. I put it in my name. It's really her house. She the one calling up here doing all this for Marlene Bridges, my daughter. It's in my name, but it's really not my house, and I'm not a landlord.
Oh.
She's in the house. She won't, all it says she want me to put it in her name. That's why she doing all this calling in and having people come out, check the house out and every other thing. She's really the owner. It's just in my name. She's been in that house since 08.
2008? Okay.
And all of a sudden now she, I got the proof right here, you know, and really it's in my name, but I'm really not the owner. She won't even let me in the house.
Oh.
So and she said, get out of her house. You know, it's really her house, but it's in my name.
Okay.
And I have proof. I don't know what name she going under. Do y'all have her name?
No, sir. We just have yours.
Huh?
We just have your name.
Yeah, but she called out for people to come out, do the inspection on the house or whatever.
Okay. She must have made a complaint to the Department of Building and Housing.
That's what she done. They came out and done it. I have proof of she my daughter taking me through all this aggravation. I'm 88 years old. I don't need all this crap. And it's my daughter, and that's my son right over there.
Mm-hmm.
And you know, I'm not the landlord. I'm not a landlord. I'm not the house owner. It's in my name. And she done sucked me up already. $9,800 for windows. I put it on my charge. And she was gonna take it. She hadn't. I had to pay for it. For the one, whole new windows in the house. The whole house. And in November, I had $1,000 and $8.46 in my checking account. She's on there too. She drew $1,000 out. Without my permission. And next week, she took $8 out and left 46 cents in my account. I have a checking account and everything here now too. And I took off my checking account. I fact about it, they took it off. I canceled that checking account. I had that account for just 70 years. I had it. I took off. There's a name right here now on there on my check. When I took off right here now.
Okay.
Marlene Bridges. She might be going under Marlene Gunn. She been separated and he's passed away and divorced and everything about almost 20 years.
Through the board to the appellant.
Pardon?
I'm speaking to you through the board, but I'm speaking to you. The property records indicate you took title to this property around 2008, so it's been in your name for a while, for quite some time.
And went to which is county building, and something happened to me. She would have the house. You understand? It's been a long ago. You understand? Her name is on. But
and again, through the chair to the appellant. Can you hear me? Okay.
Pardon?
Can you hear me? Okay.
I hear you.
Okay, I'm gonna try to speak loud. The property still is currently titled to your name, so you are the legal owner of the property.
I understand that,
and
yeah.
To clarify, your daughter is currently living
there. I'm not a landlord, see, and she give me a red penny. I'm really almost taking care of her right now.
You're very kind, sir, very kind.
Yes, you are very kind. And although the city is very sympathetic, we understand your position and we're sympathizing with you, but the property is titled to you. So you are the legal owner of the property.
The property.
And would anyone else like to speak?
Yes, my name is William Bridges.
If you could be sworn in.
Mr. Chairman, can you swear in his son?
Oh, his son, yes. What's the son's name?
William Bridges.
Okay, I solemnly swear to tell the truth, the whole truth, so help you God.
Yes, sir.
Okay, go ahead and proceed.
Well, the whole fact of the matter, I know that my father has to address these issues that have been presented to him. But what he is saying is absolutely correct. My sister is taking advantage of an elderly man here. He shouldn't be going through this. It's almost 90 years. So, I know that these problems have to be addressed, and we just want to ask the court time to let us go ahead and get these things together.
And I would ask both of you, what is your ask today? What are you asking for?
Yeah, that
you are going to have to take care of these violations. So, how much time do you think that you would need to take care of the violations?
Now, what violation you come up with? It's lead violation.
No.
These are how there's a list of things that they have that are bullet pointed. Let me.
When you came down and filed your appeal, remember you had these things?
Yeah.
We can make you another copy of this.
I know. I probably have a copy of
Yeah,
that. I probably. That's it came out interior and exterior.
Yes, sir.
Okay. All that she been in there all that time. She done all that, like
That's a rep. That doesn't matter.
Okay.
We have to address this issue, take care of it, and then we'll deal with her.
No, but
Yeah, there's
Mr. Chairman?
Yes, Mr. Vanover.
This property, as discussed, is not owner occupied, but it's not owner occupied. Right? So it doesn't meet the legal definition of owner occupied. but it is a family member and through on a whatever agreement. The city does not object to 180 days to abate the violations.
Okay.
Do that,
All right.
The violation,
There's a-
okay. 180 days, okay.
What you have to do, we gotta get a contractor and the permits and all that stuff, whatever they're asking for. I'm gonna be involved with this, so don't worry about
Very
Okay,
good.
so,
Okay, so we got,
okay,
so it'll be 6 months basically to abate the
Mr.
violation.
Chairman, this discussion, the
Go ahead,
appellant has
Mr. Bishop.
okay, what I'm trying to say, you saying do all this work already, and she's in the house.
but you're the owner. That, it doesn't
Don't-
matter, Dad.
I know.
It doesn't
You
matter, it's just
understand?
the law.
I understand, I don't know, I understand what you say, the law. I might better just give her a house.
And through the chair, both to the appellant and appellant's son. You do have other options and you can pursue them, but those aren't for the board to decide
Sure.
today.
Mhm. Okay.
Right.
But I could just give her that house then. Get it back in her name. I could do that.
And let her take care of it.
Okay, what we need at?
Nothing, you don't need anything else. We're okay?
They're gonna make a ruling,
Okay.
Right.
and then that's gonna be adopted. And then if you have other questions later on, you can call me. You can stop back at the office over at 516 to get my card.
Sure.
And I can further explain in detail.
Okay.
All right, so we're gonna do a motion as an order to get to August 15th, 180 days, 2024 to abate the violations. Motion?
Move.
Okay, Mr. Bradley,
Second.
second by Mr. Dink.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes, notice will be sent out within 2 weeks and hopefully, Mr. Bridges, you'll get the notice.
Thank you so much.
Okay, next docket,
You're done.
Okay.
A 377-23, 3906 Fulton Court.
Application and fees are in order. Notice of violation is condemnation of the main structure issued October 13th of 2023. Appeal was received October 26th of 2023, requesting for 6 months to abate the violations. Present for the hearing, Tom Vanover, Department of Building and Housing, Dan Jacobson Law. Would the appellant or his or her attorney or representative please state your name for the record?
Hi, Daisy Goddard. I'm the property owner.
Okay, what's that name again?
Daisy Goddard.
Gerard? Okay, Miss Goddard, you solemnly swear to tell the truth, the whole truth, so help you God?
Yes.
Okay, go ahead and proceed. Let us know what your plans are.
So I purchased the property in June. Unfortunately, we had a fire at the property, which was not covered by my insurance because my insurance lapsed, and I wasn't informed of that. However, I do currently have home insurance. I have a contractor who is ready to start work today if he can get everything through zoning. So I do have the budget to renovate the property. It's a side-by-side duplex, so I will be living on one side and leasing out the other side to a tenant. So this is also an FHA 203K renovation loan that I have, and that are with that, my contractor has to finish the work within 6 months, and it needs to be move-in ready in 3 months. He's confident that he can get everything done within 6 months. So I'm asking for a continuance for 180 days, please.
Mr. Vanover.
Mr. Chairman, to Ms. Goddard, just so that I'm clear, the FHA loan is in place and has been awarded?
Yes, yeah.
Mr. Chairman, we don't object to 2 weeks to make application for permits and 180 days to correct the violations.
Okay.
With the understanding that the property will be The exterior premises will be cleaned and the property will stay secure and graffiti-free until such a time as it's completed.
Yes, I have a whole security system in place with cameras and like flood sensors, fire sensors, which is why luckily the fire department managed to get there within a couple of minutes when it did catch on fire. And there's no one like living there, or if somebody did break in, I would immediately know and the police would be called. So I can guarantee that it will stay safe for the public.
Okay, very good. So it's February 28th, 2 weeks to 2024 to obtain the permits, and 180 days, August 15th, 2024 to abate the violations. Motion?
So moved.
Okay, moved by Mr. Dink. Second by Mr. Bradley.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Okay, notice will be sent out within 2 weeks. Thank you.
Okay, thank you. Have a good day.
You too.
Bye-bye.
Okay, next docket. A 378-23, 4608 West 146th Street.
Application and fees are in order. Notice of violation is no permit issued on October 16th of 2023. Appeal was received November 13th, 2023, requesting for 60 days. Present for the hearing, Tom Vanover, Department of Building and Housing, Dan Jacobson Law. Will the appellant or his or her attorney or representative please state your name and your capacity to the property?
Ron Azam, property owner.
Okay, Mr. Azam, solemnly swear to tell the truth, the whole truth, so help you God?
I do.
Okay, go ahead and proceed.
First of all, I didn't do any work without permit. This work has been done like over 3 or 5 years before I bought the house. So I understand that it was a mistake from the previous owner or the one before, and any issues, I'm gonna fix it. I just, if there is any issue, I can fix it within 90 days, because currently I was out of the country. I'll be back in 2 weeks and I'll start working on it if there is any violation.
Okay, so you're looking for 3 months to complete all the violations?
Yes.
Okay, go over to Mr. Vanover.
You're muted, Tom.
I know. Bear with me one moment, Mr. Chairman. So yeah, Mr. Chairman, there is a permit that has been issued, inspection pending. And the notice of violation has been closed, so we don't object to more time to correct the issues.
Okay, so he's asking for 90 days.
With no objection.
Okay, May 15th, 90 days, 2024 to abate the violations. Motion?
Thank you.
So move.
Moved by Mr. Bradley,
Second.
second by Mr. Dink.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Okay, the notice will be sent out within 2 weeks. Thank you.
Thank you.
Next docket, A 383-23, 6012 West Clinton Avenue.
Application and fees are in order. Notice of violation is no permit issued on October 23rd of 2023. Appeal was received November 20th of 2023. Present for the hearing, Tom Vanover, Department of Building and Housing, Dan Jacobson Law. Will the appellant or his or her attorney or representative please state your name and your capacity for the record?
Peter Glinius. I am the owner of the property at 6012 West Lane.
Okay, Mr. Glenn, solemnly swear to tell the truth, the whole truth, so help you God?
I do.
Okay, go ahead and proceed. Let us know.
Okay, so I moved in, I believe, October of 22. And I began by getting permits for the roof, exterior, and windows and siding. I had a violation for the garage, which I brought today. It actually was approved today. So I picked that up today. And then as far as the interior with the drywall, I put new drywall up. But it's been brought to my attention that there was other things that the inspector saw from the previous owner. So I guess I'm just requesting more time to have an architect map everything out and have time to get the permits brought to you for interior work. But as far as the siding, windows, roof, and garage, they have all been permitted as of current day and just waiting on final sign off and approval.
How much more time do you think you need?
To get the garage done, it took me about 2 to 3 months with the architect. So I'm thinking probably 6 months for the whole interior of the house.
Okay, Mr. Vanover.
So, Mr. Chairman, yeah, there are multiple permits in place, but this is a matter of the work that was permitted was expanded. And that's what the violation notice is for. We object to 6 months. I understand that, we don't object to more time, but I think that, 6 months to get permits is, it's too much. We won't object to 30 to 60 days to get permits.
So it's more just to have the architect draw it up so I'm okay delivering permits today if I had the architect drawn out what was prior there. But it sounds like from he wants interior of the house. The garage is completed. I have that done, submitted, and just needs to be inspected. It's the house that I would need the time to get an architect through, map, all the electrical and mechanicals that he's asking for.
To, Mr. Chairman, to the appellant, I thought someone from Landmarks Commission was gonna be here. Wasn't your house also part or fall underneath the landmarks or need requirements and approval?
Correct.
From Landmarks Commission?
And for the garage, Landmarks has already signed off on, and zoning, and then building planning has already signed off. It would be the house that would be the different part.
Okay.
Yes. That's, the house is the incomplete part as of current.
Well, you look like you're moving along pretty good though, considering it looks good.
I appreciate that.
Okay, so let's look at a June 15th date, 120 days, 2024 to abate all the violations and to meet up with the permits and everything necessary to complete.
Okay, I appreciate that and thank you for your time.
Okay, motion.
Move.
Okay, moved by Mr. Bradley,
Second.
second by Mr. Dank.
Mr. Bradley?
Yes.
Mr. Dink?
Yes.
Mr. Gallagher?
Yes, notice will be sent out within 2 weeks.
Thank you for your time.
Okay,
Thank you.
this adjudication order, we kind of agreed we're gonna move this, is that correct?
I thought you wanted to address the issue or make it, put it on public record.
Vishnu, what was your understanding here?
Mr. Chairman, for my understanding, the board was provided with more information for your consideration this morning at 7 a.m. And the board, from my understanding, the board members did not have enough time to reconcile and review the information. And that was part of your concern before having to do this real time while this was presented to the board and its members.
Right.
So that was the basis. That was what you were considering about whether to hear this today or at a later date because of the additional analysis and review that would be required.
Yeah, along with that, I think, Vishnu, is that, I think Mr. Dink is gonna have to, bow out on this
Yes.
one, I believe. So that only gives us
Yes.
2 board members, and we don't have enough to make a decision.
That,
Oh.
that is correct.
Okay, so we're gonna have to, move this one, Ms. Davis.
Okay.
Okay. So we are not gonna hear, the adjudication order docket A 1524, 1865 West 22nd Street. It'll have to be reassigned, removed.
I believe the appellants are here today. Right, you guys are here for today's docket. After today's hearing is over with and I have a chance to speak with the board members, hopefully we will be able to squeeze you in on February 28th docket. If not, it will be the first docket in March.
Okay, very good.
Mr. Chairman,
Yes,
just so that I'm clear, this is being postponed at the board's request?
yes.
We would not have a quorum, Mr. Vanover.
That also.
Mr. Dink will have to recuse himself from this hearing.
Understood.
Okay. Sorry for the inconvenience. We're going to a permit extension on housing docket A 363-23, 3481 East 153rd Street.
Wait, which one are we on?
I'm looking at A 363-23, 3481 East 153rd Street, the permit extension.
Oh, wait, okay, so we gotta read into the record a postponement of the lead.
Yeah.
I'm sorry, we moved right over lead, didn't we?
Yeah.
Okay, all right, so we have lead housing docket A 373-23, 11718 Longmead Avenue has been postponed. And the lead housing docket A 376-23, 14321 Terminal Avenue is also postponed. And we have one more lead housing docket A 381-23, 3325 West 122nd Street has also been postponed. Now we get down to docket A 363-23, 3481 East 153rd Street.
Application and fees are in order. This is the request for a permit extension. To keep permit number H as in Howard 210-21378 open. Present for the hearing, Tom Vanover, Department of Building and Housing, Dan Jacobson Law. With the appellant or his or her attorney or representative, please state your name and your capacity for the record.
My name is Zheng Hua Gu, ZHAENGHUA. Last name Xu. I'm the owner of the building.
Okay, and that's pronounced Gu?
Yes, just call me
Okay.
Gu will be fine.
Okay, solemnly swear to tell the truth, the whole truth, so help you God.
I did.
He wants you to take.
Okay.
Okay, you're good with that, okay. All right, go ahead and let us know what the plans are.
Okay, this house, we did completed the work from electrical wires, the plumbing, drywall. That was, before I decided to do this, they condemned the house. So I have to go through all the process. The contract sale is one of my friends, okay? But he recently got canceled. He was out hospital all the time. But majority things done. We have already passed the plumbing inspection. and general construction inspection. And today, the electrician inspector will here around 1 or 2 o'clock today. So pretty much everything is done, but outside, I still have like glass or some left because this guy is cancer and in or out. When he come out, he didn't have a stable employee can work for my house. Plus, he have a more project going. So I got so really upset, but there's no way, you know, he cannot guarantee, he always guarantee me, say, I will finish and finish. Surprised, we get 2 extensions. We got 2 application form. Now still haven't completed, but inside everything looks good. I put someone there to watch house for me. If you want to see the picture, I have some picture I can show you inside the house. It's pretty nice, I think. Inside, you want to see? The inside, outside, all the pictures there. But still need to get more time. And I told him how long time you need. He always, okay, I will finish this week. Oh no, I will finish this month. Every month he said, but a lot of time he's in the hospital. I cannot reach him. But I cannot leave alone get someone else getting because no one will take job something left over. Overall, the majority things is done, but small things need to touch up. So I hope we will give some attention. This time I cannot control him because he's in the hospital due to treatment.
Mr. Chairman, to the appellant, I am looking at a picture of the interior of the property.
You can see more picture if you.
Well, I want to give information, and I want to hear from Tom Van, the building official, to see what work has been done there. But for the record, I'm looking at a picture of interior of a house that looks in good condition.
Very good.
But I want to hear from the chief building official.
Yeah, I understand that.
All right, Mr. Vanover.
Mr. Chairman, there's multiple permits that were pulled on this property. The work was abandoned, and under the Ohio Administrative Code, if the work is abandoned for 6 months or more, the plan approval becomes invalid. And a new plan approval is required. That is under the building code. In this particular case, this permit, this H21021378 permit was closed as non-compliant for inactivity. So was building permit number B1021357 for this same property was also closed as non-compliant. We would ask that you uphold that and that those remain closed. There is no indication that they were improperly issued. That being said, there has since been a new plumbing permit, new HVAC permit, new electrical permit, and new building permits pulled where work has progressed under those permits, and the HVAC and the plumbing permits have been closed. The electrical permit has been inspected and shows progress, as does the building permit. So I would indicate that there are new permits in place, and the only reason that to request, and I won't speak for the appellate, the only reason to request that to reopen the old permits is to not need a new plan approval. However, the new plan approval is already in place. Work is progressing under those permits. I would ask that you uphold the order invalidating the plan approval on the permits in question, understanding that work is progressing under a new set of permits already.
Makes sense. And I think that's pretty much what you're already underneath. Yeah, makes a lot of sense. So we're going to uphold that order, and it is abandoned, and you're going on with the new permits anyway. So motion is to do that, to uphold the abandoned work permits, that they be denied, and that he's going to proceed on with the new permits. Motion?
Move.
Motion by Mr. Bradley, second by Mr. Dink.
Mr. Bradley?
Yes.
Mr. Dink?
1. 2. 3. 4. 5. 6. 7. 8. 9. 10. 11. 12. 13. 14. 15. 16. 17. 18. 19. 20. 21. 22. 23. 24. 25. 26. 27. 28. 29. 30. 31. 32. 33. 34. 35. 36. 37. 38. 39. 40. 41. 42. 43. 44. 45. 46. 47. 48. 49. 50. 51. 52. 53. 54. 55. 56. 57. 58. 59. 60. 61. 62. 63. 64. 65. 66. 67. 68. 69. 70. 71. 72. 73. 74. 75. 76. 77. 78. 79. 80. 81. 82. 83. 84. 85. 86. 87. 88. 89. 90. 91. 92. 93. 94. 95. 96. 97. 98. 99. 100. 101. 102. 103. 104. 105. 106. 107. 108. 109. 110. 111. 112. 113. 114. 115. 116. 117. 118. 1
Do we have to take care of anything else here on a timing issue for the new permits, or is he just good sailing along?
No, Mr. Chairman, the notice of violation is not under appeal, nor
Okay.
is there a right to appeal that, so that timeline runs, and the permits, the current permits run under the requirements of the Residential Code of Ohio, that as long as they are progressing, they will remain open and active.
Okay, very good. All right. Notice will be sent out within 2 weeks on that issue. You're all set, Mr. Gu.
Thank you very much.
Okay. Permit extension housing docket A 370-23, 2197 Green Road.
What?
Be careful, be careful. Be careful. Watch the court. Okay. Application and fees are in order. This is a permit extension request for permit B as in boy, 220-29220, issued on November 3rd of 2022. Present for today's hearing, Tom Vanover, Building and Housing, Dan Jacobson Law. Will the appellant or his or her attorney or representative please state your name for the record?
My name is Otis Jordan. I'm the owner.
Okay, Mr. Jordan, solemnly swear to tell the truth, the whole truth, so help you God?
Yes, I do.
Okay, go ahead and let us know what your plans are.
Okay, if I could be granted an additional 6 months to complete the project, that would be helpful. My problem was I neglected to stay in good communication with inspectors. A great portion of the work has been done. New roof, new gutters, new windows, furnace, plumbing, and electrical. The plumbing and electrical is approximately 80% complete. And could get inspectors in there as soon as possible to confirm the work.
Okay, Mr. Vanover.
Mr. Chairman, again, this property has a electrical, building, and HVAC and plumbing permits were pulled in November of 2022. And then were subsequently closed in August of 2023. We would ask that you uphold the notice or the order as properly issued. There has been multiple attempts at communication to the owner. This is a condemned structure. It was condemned in 2021, I believe. Yes, it was condemned in September of 2021. So this has been a condemned structure in the neighborhood, sitting there for multiple years. Permits were pulled, no activity, no inspections, no indication of work over that 3-year period. We would ask that you uphold the notice or the order as issued. And if the applicant wishes to proceed with this renovation, they can make application and apply for new permits.
Okay.
Mr. Chairman?
Yes.
Mr. Chairman, please. Through the chairman to the appellant or appellant's representative, Mr. Jordan, the property seems to be titled to Stay Focused LLC.
Yes.
What is your relationship to that business entity?
That's my LLC.
And how did you get notice of the permit closure? How was that? How did you get it? Do you have a mailing address that you could state for the record?
Yes, I'm sorry. That's how I got it. 960 East 78th Street, Cleveland, Ohio.
Is that the address of that? Oh, that's your current residence?
Yes.
Thank you, sir. Nothing further. Thank you.
Okay, very good. So a motion is in order to uphold the order as issued and that new permits will be required. Motion?
Move.
Moved by Mr. Bradley, second by Mr. Denk.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Okay, notice will be sent out within 2 weeks. Thank you.
Thank you.
Next docket, permit extension, housing docket A 380-23, 1205 East 113th Street.
Application and fees are in order. This is a permit extension. The request to keep permit number H as in Howard 220-26264 open. Present for today's hearing, Tom Vanover, Department of Building and Housing, Dan Jacobson Law. Will the appellant or his or her attorney or representative please state your name and capacity to the property?
Yes, good morning. My name is Brady Burns. I'm the owner.
Okay, yes, Mr. Burns solemnly swear to tell the truth, the whole truth, so help you God?
I do.
Okay, go ahead and let us know what the plans are.
Well, my plans is to continue, finish doing the violation that was on the house that was stated. I did, ran into a little bit of a finance problem. The reason why I had to put a hold to the work. And so now I'm back in the working field. And so I would like to continue with the progress on the house. I have put new windows in, the gutters that was down, put new gutters around, well, just in the front where the damage was at. They had sent me I think it was a notice for the debris that was in the backyard. I cleaned all that up. So, like I said, I just want to finish continuous with the progress because I would like to move in.
Mr. Vanover.
Mr. Chairman, this is a condemnation of the main structure and the garage. This property was condemned in, beginning in May of 2022. And, is in really, really bad shape. So the permits were pulled in, October of 2022 with no work taking place on the property and no inspections. Multiple attempts to reach out to the owner have been unsuccessful. And at this point, the electrical and this is the appeals for this HVAC permit, but there's also an electrical permit and building permit that are closed as non-compliant. It doesn't appear, and based on testimony, that there's been any progress on this 2 years old condemnation. So we would ask that you uphold it and remand it back to the department, requiring new permits, new plan approval if the appellant is serious about making the renovations.
I have started work on the house. It was damaged to the garage. I mean, the driveway side and the back side of the house. So I made those repairs. I don't have any pictures because my phone is in the car. But if I'd have knew that, I would have brought it up with me. But I have been making some progress there.
Okay, but I think what we have here is we got a problem because of the abandonment.
Through the chairman, through the chairman to the appellant, I don't want to put words in the particular, but I believe you want whole new permits.
Okay, well, if that's what I got to do, then yes.
Okay, so.
And I wanted the appellant to confirm a mailing address, if you could.
Yes, 3347 East 134th Street. That's Cleveland, Ohio, 44120.
Thank you, Mr. Chairman.
Yes.
Okay. All right, so we're going to motion to uphold the order as issued and to remand it back to the Division of Building and Housing to notice to have to obtain new permits for the property. Motion is so in order. Moved by Mr. Bradley.
Second.
Okay, second by Mr. Dink.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes, notice will be sent out within 2 weeks. Thank you.
Thank you.
Okay. All right, I think we've covered all the dockets. Is that correct?
That is correct.
Okay, approval of resolutions. There is one, A 218-23.
Motion for approval.
Okay, okay, motion, Mr. Dank, second, Mr. Bradley.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Approval of minutes for January 31st, 2024. Are there any additions or corrections?
No.
Motion.
Move.
Okay, moved by
Second.
Mr. Bradley, second by Mr. Dank.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Do we have some further business, Ms. Davis?
No.
We set to shut down the video?
The live,
Yes.
1 second.
Get information.
So go up, when you go up in the menu, and or you go into YouTube.
Go into YouTube.